So next up we have the guys from Bartier Perry. We've got David Creais and Mark Glynn here again. So we've got the bios here for the guys. I think we're very familiar with them, but as a general introduction for those of you who don't know, David is a partner in the building and construction team at Bartier Perry. He's been practicing commercial law and commercial dispute resolution for over 30 years. Clearly started his degree when he was 5 years of age. David advises on all manner of building and construction issues, from front-end contract preparation, negotiations, risk allocation, administration of contract during the program, and back-end dispute resolution and contract termination, which is usually where we get involved. Mark is also a partner at Bartier Perry in their building and construction law subject matter expert, who assists principals in contracts, subcontracts, consultants, project documentation, delivery of and administration of a range of construction and development projects. Recent projects that Mark's been involved in include commercial, industrial-based building projects, significant corporate refurbishments and fit-outs, data centres for major Australian banks, an aquatic centre and a library for a local council. So with that, I'd like to introduce the team from Bartier Perry.
Which one of these do I? Yep. All right. Thanks, Mark, and thanks everyone for the opportunity to come and present to you today. In keeping with the theme on inspection and detection technology, David and I are going to do our best to stick to that theme. We've certainly, but come at it from a slightly different angle. We're going to come at it from the angle of the recent building reforms and look at aspects within those reforms, in part where there are certainly inspection and detection reforms that have been introduced. We're going to look at, we've talked briefly at some of our, I think it was back in the June meeting, we talked about these reforms that have come in through the enactment of new legislation. But we're going to endeavour in this presentation to look at aspects that are consistent with the theme of inspection and detection. I'm not sure how we're going to go with technology. That might be a bit beyond our brief here today. And also look at areas under these reforms where we think that you members may, by choice or otherwise, be required to engage with. So hopefully we'll be able to, where possible, link some of these reforms back to either opportunities or aspects that may involve yourselves as building consultants. So the reforms, and I know I've been banging on for a while about this Shergold Weir report, but a lot of the reforms that we're seeing come through have their genesis or their origins in the Shergold Weir report, which was the report that was commissioned by the building ministers, in response to some of the incidents we saw, in particular the Lacrosse cladding fire down there in Victoria, followed by Grenfell, and some of the incidences that subsequently occurred. And we saw this report that was, the terms of reference of this report were to examine the compliance and enforcement problems in the construction industry affecting the implementation of the code, and to look at strategies for improving compliance with that. And that report was handed down in February of 2018. And what that report found was that accountability was unclear, and that documentation, in particular in relation to design, was poor. And so there was also the documentation, there was no real requirement, or the documentation lacked a requirement to demonstrate compliance with the code. So the Shergold Weir report put forward a number of recommendations, and to paraphrase the New South Wales Building Commissioner David Chandler, he talked about establishing the trustworthiness of buildings by having trustworthy certificates provided by the various consultants through the delivery process. And I think that's where these reforms you'll see, a lot of the reforms are aimed towards restoring the confidence back for the trustworthiness of the final built product, and that is achieved through the providing of complying and trustworthy certificates. So the New South Wales government responded, as we know, to the 24 recommendations that the Shergold Weir report made, and it announced that it was going to implement 4 reforms. The first one was the appointment of the building commissioner, which we've seen happen. The next one was the overhaul of compliance reporting. A third was requiring the registration of practitioners, those being building and design practitioners and those that had obligations under these reforms, and then also an industry-wide duty of care. So in the next step in achieving these reforms has been the introduction of 2 new pieces of legislation, the Design and Building Practitioners Act, or the DBP Act as it commonly now seems to be referred to as, and the Residential Apartment Buildings Compliance and Enforcement Powers Act, or the RAB Act. And then there's also was an amendment made a couple of years to the Strata Schemes Management Act, which is consistent with these reforms. And they're the 3 reforms that we're going to deal with today. We're going to do a bit of a tag team approach between David and I, and one of us is going to do the funny stuff, so I'll let you wait in anticipation to see who that's going to be. So now just get David to pop up and talk about the Design and Building Practitioners Act.
Good afternoon, gentlemen, and Joe's outside. As Mark said, nice not just to see your faces, but be in the same room as your faces after a long time. So great to see you all. That bio that Mark read, it's a little old, I think. It's actually 35 years this year, but there you go. Right, so Design and Building Practitioners Act. So as you see, there's 3 main parts to it. Registration of building practitioners. Now, as you also see, this is in advance. It starts in July 2021. One of the reasons for that is because we don't actually know who the building practitioners are at the moment. That's subject to the regulations, and the regulations haven't been written as yet. So the government's given itself time to iron out the wrinkles, so to speak. We think. Compliance declarations, so these are declarations by building practitioners that the design and the building complies with the relevant rules and the building code and the development consent. And lastly, and really the sting in the tail, is the duty of care. Now, as you see, this has already commenced on the 11th of June 2020. Now, I'll say a little bit more about the duty of care in a short time. So let's move to the first thing, and that is the registration. So we know it's going to be designers, engineers, specialist practitioners, and it seems that will cover people like architects and also builders. And there will be requirements for professional indemnity insurance for all those people. That won't be anything new, I guess, for people like engineers and architects, but it will be something new for builders if it's going to cover just general building work as opposed to the design aspect, and some others who might be pulled into the need to register. And that may be building consultants, or an aspect of what building consultants do. So, for example, if you're writing a scope of works for rectification, you may be pulled into this. Now, we don't know that for sure, but that'll come out in the regulations, but that is certainly a possibility. And as you know, whilst because of the good graces of and the great ideas of the society, if you're a member of the society, you need to have professional indemnity insurance. That is not a universal requirement that's written in law. So that's the registration. I think important thing from your point of view is this statutory duty of care. Now, we know that under the Home Building Act, there is a statutory warranties that are implied in every home building contract to follow the plans, construct in a proper and workmanlike manner, etc., in accordance with the consents. But this is outside that. This is a wider duty of care, which is really very similar to negligence. So, under the law of negligence, if someone fails to take reasonable care and causes loss, then that person can be sued for negligence. In other words, a failure to use due care and skill, you can be sued for negligence. Now, there's been a couple of cases in the High Court here in Australia which has found that with the advent of the statutory warranties, there is no duty of care by builders outside the statutory warranties. So this is an extension, and one of the important things about this extension is that it's owed to the owner of the land. So the owner of the land can sue anyone who carries out construction work, and I'll come to that in a minute, for breach of this new duty of care. So the duty of care is to exercise reasonable care to avoid economic loss caused by defects in or related to a building. Now, who owes this duty? That is really the sting in the tail, insofar as it's not just the builder, it's everyone who's involved in construction work. And it is conceivable that that might extend to consultants who write a scope of work or who supervise rectification work. There's also a question as to whether or not it's your company, so most of you will work through a privately owned company. It may be that that company structure doesn't protect you, and that it's the individual who can be sued, because the word that the Act uses is person. So now my interpretation of that is, in accordance with the Interpretation Act New South Wales, that person can mean either corporation or individual, and that in the context, because presumably if you are contracting to do work to write a scope of works or to oversee rectification work, you will be contracting through your company, and therefore the interpretation should be the contracting party is the person who is doing the construction work. But it's untested at this stage, and I know of at least one case in which a consultant is being sued personally for a scope of works that was written by that person, notwithstanding that that person contracted through their private company. So something to be very aware of. Now, you'll see that the construction work we're talking about includes residential building work within the Home Building Act, and other buildings to be prescribed by the regulations, but again, we don't have the regulations as yet to extend that. So it certainly applies to residential building work. Now, all of this means and has resulted in current claims, in current proceedings being amended to add a breach of this new duty of care, because it's effectively retrospective. It goes back to 10 years. So if a defect has become apparent in the last 10 years and there are proceedings on foot, those proceedings can be amended to include this new breach of duty of care. As I mentioned earlier, individuals are being targeted, and what's this doing? It means that in current proceedings there are delays in getting to trial, because as you may imagine, a lot of these proceedings are already a way down the track. Some of them have hearing dates, and all of a sudden the plaintiff owner is amending their claim to not just add an extra cause of action against the builder, but in some cases to add defendants. So remember, it's anyone involved in construction work, so the owners may be having a go at architects, they may be having a go at individual contractors, and not just going through the builder. So it's causing a bit of an explosion at the moment. It's still very early on. There haven't as yet been any cases that have been decided under this new duty of care, but there are a lot of cases out there that are being amended and are washing through the system. And if I can give a little plug to the firm, we're actually doing a webinar tomorrow morning with a barrister who's works in the construction area, and he's going to tell the webinar audience a bit about his experiences so far with these claims and these amendments. So if you go onto the Bartier Perry website, you'll see the link there through to the webinar tomorrow morning at 10 o'clock, I think it is. So there's more on that, more detail on this. The other thing I've got there is talking about proportionate liability deflection. So you may or may not know, under the Civil Liability Act, where a claim is brought for failure to exercise due care and skill, and that's essentially what this type of new duty is about. In most cases, it would be a builder who is sued can say, well, I'm not totally responsible for the damage. These other people are responsible, and usually they'll point the finger at subcontractors and consultants, and the plaintiff is then at risk if the plaintiff doesn't join those parties to getting a judgment for less than the total amount of damage if the court finds that the principal target, the defendant, in most cases again the builder, wasn't wholly responsible for the damage. Now, you can't do that at the moment for claims under the Home Building Act for breach of statutory warranties, but there's nothing currently preventing that kind of what I call proportionate liability deflection happening in a claim under the Design and Building Practitioners Act. Food for thought there, but while you're digesting that I'll pass over to Mark, who will talk about the Residential Apartment Buildings Compliance and Enforcement Powers Act 2020. Bit of a mouthful.
Thanks, David. Okay, so the other piece of legislation that's been introduced to bring about these reforms that were announced is this Residential Apartment Buildings Compliance and Enforcement Powers Act. This act came into being and commenced on the 1st of September 2020, so it's a new one, it's just come in, and it's basically giving a lot of power to the Building Commissioner to carry out investigations. It applies only to Class 2 buildings or buildings that contain a Class 2 component. And the New South Wales Government on its website has said that this Act will boost the Building Commissioner's power to stop dodgy builders and developers in their tracks. So you can see that everything's leading back to trying to ensure that what is delivered at the end of the day is a trustworthy, compliant product that people can safely move from purchaser into owner of. And how does it achieve this? Well, what this Act does is it provides the Building Commissioner with extensive and broad investigative powers. So the Building Commissioner has powers similar to those of Safe Work, and I'll talk a little bit more about that shortly. It also requires developers to provide in advance a notice of expected completion dates. So, and then there are some other Act that provides also for offences and also some personal liability for directors. But in keeping with our theme of inspection and detection, I just want to concentrate on those first two, the powers of the Building Commissioner and the requirement for developers to provide advance notice. Practically speaking, what that means is that the Building Commissioner will effectively, to use the government's words, stop dodgy builders by getting advance notice from a developer when a project is approaching the expected completion date. That notice has to be given between 6 and 12 months prior to the expected date, and that will then allow the Building Commissioner to determine whether he wants to exercise these investigative rights and powers that it has in respect of any particular project. What the Act then allows the Building Commissioner to do is to make an order in certain circumstances to prohibit the issue of an occupation certificate or the registration of a strata plan. So again, in keeping with this concept of stopping dodgy builders in their tracks, that will obviously have that effect, failure to obtain an occupation certificate. And the Building Commissioner can issue that order in circumstances where the developer didn't give the notice of the expected completion dates, or serious defects have been identified, or the building bond required under the Strata Schemes Management Act hasn't been provided. So the point out of that for the purpose of this discussion today is you can see that there's a strong incentive for developers to ensure that they give the building commissioner their notice of their expected completion dates, which then leads very nicely into this concept of providing the building commissioner with a period of time to determine whether or not he wants to engage with this particular site and activate his investigative powers. And what they've done, the building commissioners, developed this concept of a occupation certificate audit and inspection process. And this audit process is going to work off these notices of expected completion date. And what the building commissioner has done is he's set up a whole lot of risk rating tools that he's going to use that are going to run their eye over the documents that have been lodged in respect of a project. And the requirement is now that they will all be lodged through the government's e-portal. So there'll be all the documents in relation to a building will be accessible in the one place. And then look at the notice of expected completion date and determine whether or not a site is to be selected for this occupation certificate audit process. So the audits eventually will not be random. What they're going to do is that they're going to assess or make an assessment of the likelihood as to whether or not there's going to be serious defects in a project, and those sites will be identified and selected for the audit process. And so the building commissioner is going to use a number of risk rating tools in this selection process. Apart from that, they're going to also talk to other departments, Safe Work, Fair Trading, and have a look and see whether there's been any issues raised with those regulatory authorities in respect of a site. And it's going to look at use these rating tools from what they refer to as a single view of a building. The commissioners formed a view that there's a correlation between issues such as site safety and waste management and the probability of a non-compliant work. So again, as I say, they're going to look at the single building, look at issues that have been raised with other regulatory authorities, and use that as one of their risk rating tools. The other tool that they're going to use is what they've referred to as the multi-party rating tool. So again, the commissioners formed a view that there's a correlation between teams of developers and builders and certifiers that can give rise to, or can create a correlation between certain of those teams with non-compliant work. And so what they're going to do is that they're going to look at the individual risk rating of the builder, the developer and the certifier, and look at them in an aggregate to determine whether or not, in their view, this project with that team of people delivering, or that team of professionals delivering that project, warrants an audit process to be engaged in that site. They'll also look at other triggers such as missing or inadequate documentation. So currently what the building commissioner is saying is that for the months of September and October there will still be a manual selection process. He's indicated that for the months moving out to February 21 there'll be a combination of manual and automated processes using these risk rating tools. And from March 21 it'll all be an automated process. So the point here is that sites will not be selected on a random basis. They'll be selected having been assessed by these automated risk rating tools. The process then will be, and I think that in keeping with wanting to highlight some of the reforms that you guys may come across, is that you may be involved in this audit process, either assisting or as a result of some of the fallout of an audit process. The process is that the developer and the builder will be notified that their site or their project has been selected. Excuse me. They'll be issued with a notice requiring certain documentation to be submitted to the building commissioner, and they'll be invited to a briefing session. Then the audit team will conduct a desktop review of the documentation before they go out to site, and then they'll head out to site. And they're giving an indication that they may spend anywhere between 1 and 3 days on site. Whilst on site, they've got the same powers, as I said earlier, as Safe Work to request information, to ask people to answer questions on any particular matters relating to the site. They've got a power to enter without a warrant into premises at any time where they think there's information that can be gleaned. So they've got some very extensive powers, and they're certainly indicating that they're going to be active and heading out to site. As a result of an audit, 3 things can happen. There can be nothing detected, in which case the project just continues on towards getting its occupation certificate. or a prohibition order can be issued. So that's the order from the building commissioner where he issues an order that an occupation certificate is not to be issued, or a building rectification works order can be issued. And that's an order where the building commissioner has identified a serious defect. He can order that the rectification work can be carried out. Now this, I think, is somewhere an area where you guys may get a requirement or may get involved in, because where the commissioner issues a notice of intention to issue a rectification order, the developer has an opportunity to provide submissions back to the commissioner, and the commissioner is under an obligation to consider those submissions. So, you know, you may be required to engage with the developer in working up submissions as to why a rectification order is or is not appropriate in the circumstances.
Mark, it's come to the attention of the master builders that there's a project in Coogee where the commissioner has ordered 300 bathrooms to be stripped out and waterproofing redone. And there's another project, I don't know where the OC has been knocked back.
Right.
Just in the last week or so.
Yeah, yeah. Interesting. I mean, this building commissioner is very active out there. He proudly announced at the beginning of September or shortly thereafter that the first of the 200 occupational certificate audits that were to commence on the 14th of September had been identified and were about to undertake. So to your point, Michael, he's out there doing these audits. He's formed a view that he believes that if a higher effort is made at the beginning of the process, then it'll have the greater impact. When I say the beginning of the process, before OC, as opposed to the current regime we've got, where all these defects get identified after OC or at the back end, when there appears to have been little impact in terms of improving the quality of the standard. So that's the audit process. I just wanted to step that out for you so you understood it, because there might be, I sense that there may be some opportunity or some requirements on you as building consultants to get involved in that process where, you know, a developer or a principal comes to you as subject to the audit, how it may unfold, and also where rectification orders have been issued. So if a serious defect is found as a result of any of the investigative powers, but particularly as we've just talked about this one leading up to the OC or a defect identified through the audit process, the commissioner can prohibit the issue of the occupation certificate or issue a building rectification work. In issuing a building rectification work, he's got to provide the builder or the developer with a reasonable time to do that work, but he may actually specify the standard at which has to be done in terms of that rectification work has to meet. And if the builder or the developer, doesn't undertake that rectification work, there is scope for the building commissioner to do whatever is necessary to carry out that work himself with an ability to recover the cost thereof back from the developer.
Excuse me, is there any retrospective work, say, with the Opal building where there's been major defects, an occupation certificate was issued, and then rectification was then undertaken? Is there anybody to then supervise that rectification work for the occupants and the owners of that building under this new legislation?
Nothing under this new legislation, no. This new legislation is designed at providing the commissioner with powers leading up to the making the application for the occupation certificate, and the big stick that he wields is that he can prohibit the issuing of the occupation certificate, and that's in keeping with that comment of stopping dodgy builders in their tracks. So he can issue an order that prohibits the issuing of an occupation certificate, which will have that effect.
Do you think it's likely though? Like in the past we've seen, I'll mainly talk residential obviously.
Sure.
You know, rectification work, rectification order by fair trade will be issued all the time, and the builder just doesn't rectify them, just ignores them. Their licence never gets taken off them. The repercussions is worse than nothing.
Mm.
Do you think this will have a bit more clout?
Well, I think it will have some clout, because unless the work's carried out, or unless the order prohibiting the issuing of the occupation certificate is lifted, and it would only be lifted if the defects have been rectified, or the appropriate documentation had been lodged, and it goes back to these compliance certificates that David was talking about under the Design and Building Practitioners Act that have got to be lodged. Unless those are all complied with, then a developer won't be able to get an occupation certificate. And I think, absent the occupation certificate, they're really, to some extent, stymied.
Yeah, just a question. With the Design Practitioners Act, there's developers are excluded from that, so the emphasis on that is for the builder and
Absolutely, yes.
certified.
That's right, the builder to ensure that the...
And if we come to this particular act, what if you get a particular builder that refuses to do the work and then is found to have issues on other sites? Can the Commission take action against that builder's licence?
Well, I think under the registration process, to one of David's earlier points, under the Design and Building Practitioners Act, there's going to be this whole class of registration of not only builders, but also various consultants involved in the process. And one of the reasons behind having this registration is so that things like disciplinary action and additional education and continuing development strategies can be taken. So I would suggest that yes, there would be opportunities for registrations to be cancelled. And if you don't have the registrations under those Act, you can't lodge compliance declarations, or as the builder, you can't lodge a complying declaration that says that the building has been constructed in accordance with the regulated designs.
I think, David, too, the other part of it is, if they're subject to the registration, the builders are subject to the registration order on one site, that's likely to lead to further audits on other sites. Developers aren't going to be very happy that their sites are being audited, and so that's going to be a break on the builder as well, and also encouragement to the builder to make sure he's doing the right thing, because otherwise he's not going to get new contracts and he won't have a pipeline. I think it's also the case that developers aren't necessarily immune or outside the provisions of the Design and Building Practitioners Act, because part of the definition is someone in control of construction work. So it may be the developer, in certain circumstances, depending on how much control over the construction the developer has retained in its contract with the builder, the developer may well fall within that act.
Yes, but with your Design Practitioners Act, there's a duty to the owner of the land. The owner of the land would be a developer. A duty of care with the owner of the land.
It may be the developer, but it applies to successive owners as well. It's not just the owner at the time. So in that way, it is similar to the statutory warranties, but it's different to the statutory warranties insofar as it has a much broader reach.
I think we're entering time over the next 2 years. A few of these cases come through, we're starting to have some understanding.
Absolutely.
And,
Yeah.
that's good.
And to your point about if a builder or developer has a number of sites where they have been issued, when he makes an application for or puts his notice of intention to make an application for an occupation certificate into the Commissioner, and they look at this multi-party rating tool, and they look at this builder or this developer who's got other sites that have had issued, there's the higher probability that that site will be selected for an audit. I mean, the Commissioner's made it quite clear that he intends to tell the world about good buildings and good developers and good builders, and that they, potentially will not be subject to random audits, but that he'll be concentrating on the end of the spectrum where there are those that are not delivering a trustworthy product. Okay. So moving on, just very quickly, in terms of what is a serious defect, I think we've been through this a couple of times, or at least in that earlier presentation that I referred to, but it's a non-complying building element, being a building element that doesn't comply with the BCA or the relevant standards. Any defective building element which has had a defective design or issue, so these are what the Commissioner will look at in the definition of a serious defect, or any non-conforming building product, so the use of a building product such as combustible cladding with the 30% polyethylene core that is now a banned product, they will constitute a serious defect. Just one thing to be aware of, and we've stressed this previously, is that there is a difference in the definition of a serious defect under the RAB Act versus what is a major defect under the Home Building Act. So the There's a couple of common ones there, obviously the fire safety systems and the waterproofing and the load-bearing components. But you can see here they've added this component of a building enclosure, and I suspect that that's got something to do with cladding, because cladding obviously, building enclosure being defined as something that separates the inside from the outside, and obviously cladding, depending on how it's being used, would obviously fall within that as a component of a building enclosure. So just bear that in mind. So I think that just in conclusion on this part of the Act, that there is obviously going to be some more inspections through the audit process, some more detections of serious breaches or serious defects that will have some ramifications, all aimed towards whether or not a developer does or does not meet his occupation certificate.
Now, I think the third piece in the puzzle of this legislation, and yes, the Strata Schemes Management Act, or that part of it that relates to the need of a developer to provide a building bond, came in first. Applies to contracts between the developer and the builder entered after the 1st of January 2018. So you might say, well, this is a bit old, but the point is that it's all about when this bond becomes active, in the sense that when the inspections are going to take place. So, as you may well imagine, enter into a contract, particularly for a multi-storey building, 1st of January 2018, you're not going to get a start for a little while. So it's now, 2 years later, that these buildings are coming on stream, where the scheme really is going to start to bite, and hence the activity from fair trading, and indeed your own society, which has now managed to get itself on the list as a nominating or authorising authority to nominate inspectors to go out to take part in this regime, which, as you'll see, multi-storey buildings, 4 storeys and above. So, in other words, where the Home Building Act and the requirement under the Home Building Act for home warranty insurance ends, this comes into play. And so the idea is that there's a fund of money, 2% of the construction cost, that's put into a trust fund by the developer against defects, or the rectification of defects that are discovered when the building's complete. As you see, there are 2 types of inspections, or 2 points for inspection. One's an interim inspection, 15 to 18 months after the building work's finished, and then there's another one, 21 to 24 months after the finish. And the idea is that the inspector goes out, has a look, does that interim inspection, says, well, yes, there are these defects, they need to be sorted, comes back sometime later to see whether or not those defects have been rectified. If they haven't been rectified, then there is access for in that case, in most cases, it'll be owners' corporation, to the bond to help pay for rectification. That's a fairly high-level overview of the scheme, but that's the way it works. Now, we've been talking a bit today about liability, and particularly relevant to the society and guys who might go on the panel, is their own liability, which is something we've been talking about in the Strata Schemes Inspection Panel Committee. And there is in the legislation an exclusion which basically says that an inspector can't get sued unless he has done something without good faith. There's been an act or omission in the purpose of doing the inspection and doing the report and overseeing and making sure that the builder complies, that has been done without good faith. In other words, there can be negligence, but in that case, you aren't able to be successfully sued, and I stress successfully sued, by the developer or by the owners' corporation. And I say successfully because there's nothing stopping someone actually commencing proceedings. It's whether they're then successful. And this good faith test sets the bar quite high. So, unfortunately, like many of these things, there's no definition of good faith in the Act. but at common law from the cases that have come through. Essentially, it means that you need to act honestly, with sincerity, not arbitrarily, not for some irrelevant purpose, not with any bias, not with any preconception. So it's a relatively high standard, and you would think that there wouldn't be many cases in which that standard would be breached. So there's some protection for the inspectors and indeed the authority which is managing the panel within the Act. So that's part of the good news. It's also been suggested to me that there is also the availability of experts' immunity. So what's experts' immunity? When it's really expert witness immunity, and this means that in the course of providing expert witness services, an expert witness can't be sued for negligence, for acts or omissions where he or she might not have acted with due care and skill. And the basis of it is that witnesses should be able to give their evidence freely in the higher interests of justice, so not looking over their shoulder all the time as to whether or not they're going to get sued. And also it helps to preserve the finality of litigation. In other words, if you have a case and the expert gives some evidence and it's said that expert in formulating his or her opinion was negligent, then to sue that expert, you're going to have to run the case all over again. Now, that's not in the interests of justice, and so that's one of the main reasons why we have this expert's immunity. But the kicker is it's only in relation to expert witness services. So it's only in relation to things that you do that are connected, intimately connected indeed, it's been said, with the giving of evidence in court. Now that doesn't mean just giving evidence in court. So your investigations, your reports, all of which are done for the dominant purpose of giving evidence in court, they are all covered by your expert witness immunity. But if it's not for the dominant purpose of giving evidence in court, then it's not covered. So if you're providing an opinion, a report to a client before litigation has started and it's just part of the investigations, then that probably won't be covered. And that is the connection between this and the Design and Building Practitioners Act, and also the Strata scheme's bond scheme. When you are doing those inspections or you're writing a scope of works, you're not doing it for the dominant purpose of giving evidence in court. So expert witness immunity does not apply in those circumstances. So you do have, under the Strata scheme's bond scheme, the availability of that exclusion as long as you're acting in good faith, but you don't have that under the Design and Building Practitioners Act. So, as David was saying, it's all going to wash through in the next couple of years, but you really need to have an eye on that. That's our Mark and my presentation. We're running a bit over time, so there's probably not time for questions now, but I think you guys know where we are, and so happy to take questions offline. Mark did mention we usually inject some humour, try to inject some humour into the law. I did have a bit of a story for you, but given the time, I won't go into that. I'll just make a... Come on. Oh, all right, okay. So I'm just going to go to my notes here, and I guess COVID, desperate times, desperate measures. This is a story about a lawyer in the UK. Clearly got a bit desperate, and what he did was he went to the family court in the UK in a bid to stop his wealthy parents reducing his allowance. Now we're talking about a 41-year-old, who's the man, because it's a family court, they use pseudonyms. He was only named as FS in the judgment. You can work out your own acronyms for that. As I say, he's a middle-aged guy. He's had a history degree and a master's in tax with the Advanced Institute of Legal Studies, but he'd been unemployed for several years. His rich parents lived in Dubai, and he went to the family court and said that his human rights had been breached when they significantly reduced his allowance and stopped paying the utility bills for the central London flat in which he'd been living rent-free for 20 years. The judge described the case as most unusual, and indeed said that most lawyers would have a robust disbelief that there is even an arguable substance to any of it. Nonetheless, this poor, destitute student who was suing because his allowance had been reduced managed to get himself a QC to represent him. The QC said that it was a breach of his right to life under Article 2 of the Human Rights Act, because the parents' plan was one of starving him into submission, not just metaphorically in intent, but literally in effect. The judge described that argument as risible. Also breaching his human rights to privacy if they stop paying his utility bills. The QC argued that the parents were simply being asked to put their hands in their pockets and they had plenty of money available. And the judge said, well, available here has the connotation of willing to make available, and that it seems that they are not. So he said ultimately that the fact is that an adult son has chosen to make financial claims against his parents. In that endeavour, he has utterly failed. There's no reason at all why he should not suffer the consequences, and he ordered him to pay his parents costs of £57,000. So most of us don't have kids like that, I hope. Thanks, gentlemen.